This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. If you have an immigration problem, whatever it is, please get in touch with me and I'll do my best to help you. Today I'm going to be talking about some good news about how you could potentially avoid paying the Home Office's extortionate fees for making an application, and whether that be human rights or a family application or any other type of application. I've already done a video on Home Office policy on fee waivers. Now it's slightly been relaxed. And therefore, if you're thinking of making an application to the Home Office, then this video and the new case law on it, as the court appeared to have compelled the Home Office into a U-turn, could be of some use to you. There is, following the case, an important update in the policy surrounding fee waivers. There was a case in the Upper Tribunal called FE, which was heard in June, and as a result of this case, the Home Office has agreed to review and amend its policy on fee waivers, which is welcome news. The case concerned a single father of 2 children. He made an application for a fee waiver in September 2021 in preparation for an application for leave to remain. Fee waiver applications will continue a person's Section 3C leave so long as you make your application for a fee waiver before the expiry of your visa, and the fee waiver will essentially extend your leave. Once a fee waiver is decided in your favour, you'll have 10 days to make the application the application for a visa, or if it's not, you've still got 10 days. But the question was, is this 10 calendar days or 10 working days, and when does time start to run? In the Upper Tribunal case, the Home Office sent their decision on the fee waiver on the Saturday the 20th of November by email. Good to know that they're working at the weekend. The email was not read until Monday the 22nd of November, and the application was made 10 days after that on the 6th of December. So that if what we consider is that time started on Monday, 10 working days after the date, this would be Monday the 6th of December when the application was made. A more restrictive way of looking at it would be to say that the first working day was Monday the 22nd, meaning that time ran out on Friday the 3rd of December. This would be the interpretation the Home Office took, a restrictive interpretation, because when the applicant's employers did a right to work check on him in June 2022, it came back negative with obviously huge consequences. This was challenged. The Home Office said that his leave to remain application had been made out of time. Suddenly he had no valid leave, no right to work or rent, and had to provide for his 2 children subject to the hostile environment. The Home Office position was that his Section 3C leave was broken. This obviously has huge implications for him and may have in fact affected his entitlement for indefinite leave to remain in the future. The case noted that the Home Office needed to clean up their guidance in this area. Thankfully, the Home Office has agreed to review the policy within 6 months. This will confirm when time starts and whether a person has 10 days or 10 working days. It will also hopefully allow Home Office staff to exercise their discretion to take individual circumstances into account, including the best interests of the children in this sort of borderline case. This is good news in respect of a relaxation as to the time frame, and hopefully the Home Office review will be positive. In practical terms, often I have individuals that come to me that qualify or get a fee waiver, and there's an awful lot of work that needs to be done to get the fee waiver application approved, and then there's the pressure afterwards in order to make the application. And obviously sometimes Home Office come back with a lot of questions in respect of making sure that the person does actually qualify for the fee waiver itself, which is no bad thing in itself, but it can cause problems for individuals in the short and long term. So it's worth reminding people again that the fee waiver policy, as previously indicated, has been relaxed. The test is affordability, not destitution. And so if you are thinking of making an application, or you're thinking you might have an application, then get in touch with me and I'll do my best to help. Thank you very much for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.